Good day, future lawyers. Our video for today is on how to paraphrase and avoid plagiarism. Plagiarism is a breach of academic integrity. It is the principle of intellectual honesty that all members of the academic community should acknowledge their debt to the originators of the ideas, words, and data which form the basis of their own work. Unintentional plagiarism. Not all cases of plagiarism arise from a deliberate intention to cheat. Sometimes, students may omit to take down citation details when taking notes, or they may be genuinely ignorant of referencing conventions. However, these excuses offer no sure protection against a charge of plagiarism. Even in cases where the plagiarism is found to have been neither intentional nor reckless, there may still be an academic penalty for poor practice. Plagiarism in the Philippines is a serious and often considered unethical transgression. People were outraged when a senator was alleged to have plagiarized a speech of a U.S. senator. In one case, the Supreme Court had the occasion to discuss thoroughly plagiarism. Plagiarism, a term not defined by statute, has a popular or common definition. To plagiarize, says Webster, is to steal and pass off as one's own the ideas or words of another. Stealing implies malicious taking. Meanwhile, Black's Law Dictionary, the world's leading English law dictionary, quoted by the court in its decision, defines plagiarism as the deliberate and knowing presentation of another person's original ideas or creative expressions as one's own. The presentation of another person's ideas as one's own must be deliberate or premeditated, a taking with ill intent. And now on how to avoid plagiarism. A student or a legal researcher is bound to observe the best practices in legal research and writing and to exercise diligence in order to prevent the commission of plagiarism. Essentially, the first way to prevent plagiarism is to be ingenious and progressive. Write something new and original. Truthfully, however, legal research and writing requires authority and competent information. A good practice in legal writing is to paraphrase. Rewrite the commentary, information, or doctrine in your own words, keeping in mind the idea and key points of the original source. Let's distinguish summarizing from paraphrasing. Summarizing involves putting the main ideas into your own words, including only the main points. Summaries are significantly shorter than the original and take a broad overview of the source material. Meanwhile, paraphrasing involves putting a passage from source material into your own words. A paraphrased material takes a somewhat broader segment of the source and condensing it slightly. A very important practice in legal research and writing is to cite your sources to provide support for your arguments and to produce a credible output. It is indispensable that you cite the articles and information that you paraphrase. lest it be a case of plagiarism, albeit unintentional. Remember, although you are restating the contents in your own words, you must give credit to your original source. Considering that it is not your original idea, as in fact, it came from legal, judicial, and academic teachings of authorities who possess superior or specialized knowledge in that particular field. These authorities and bright legal minds have done their own research and study, hence, they deserve to be credited for it. Exert effort by doing extensive research to update yourself with the prevailing laws and jurisprudence. That way, you are able to present accurate and competent information. Review your work responsibly and make sure you do not commit that mistake of forgetting or failing to cite your sources. Also, be innovative, proficient, and brilliant, and find that in the future, you and your works will be cited too.
Thank you so much for watching. That's it for our video for today. I hope you subscribe to Pinay Jurist on YouTube. I wish you all the best. Bye!